Good morning, everybody. It is Thursday, July 13th. I'm Jane Johnston with the Bar Hill Group at Remax Most, and I'm here with my best friend.
Good morning, Victoria. Who's your best friend over there? Wait, point in the right direction, and maybe. Okay, I'm with stupid.
How is your week?
It was good. Yeah, really busy yet again. Finding it really busy out there.
Yes.
So it's been good. I'm hoping to get away a little bit tonight. Going to go up to Shawnigan and visit a friend. But also, yeah.
I had multiple offers on my listing on Feltham, so that's going unconditional today. But what's different? Somebody asked me, what's different from the market this year compared to last year? Last year, I found when we got multiple offers, they were going over asking. Of course, they stopped at this time last year, like in May. Now they're going at or just slightly above asking. So
yeah, or under. I've been involved in multiple offers where they're all under asking price, and yeah, it's kind of interesting. People wanting to buy but not wanting to pay the full price, and still willing to compete, which I find really, really interesting and fascinating.
What I find interesting is when somebody comes in like really low in the competition because they're just pushing the price up. I think it's to me, it's if you're not going to go all in, don't go in. Like if you're not going to put your best foot forward. So sometimes you only get one kick at that can, right?
That's why I think a lot of buyers have said, I don't want to quote play that game where all I'm doing is helping to drive the price up if I'm putting my hat in the ring. On the other hand, they don't put their hat in the ring and then they see the property went for a price they would have paid. And they're like, oh my God, why didn't I do that? Why didn't I write an offer? So it's an impossible thing to predict fully what's going to happen. So that's where I say, write what it's worth to you if it's a property that's of interest to you, but it might drive the price up.
Right. And you're not gonna get the property if you don't write the offer.
Yep.
Okay.
Talking stats today a little bit.
We're talking stats, and then we're gonna bring Nicholas, or Nick, as I've heard him being called, McKnight in. So let's just first of all do this. Today's topic is when should you get your will done? When should you plan your estate? And what is probate and how does it work? We get asked these questions all the time, and Nicholas is going to discuss that with us. But first, let's do the stats.
Okay. Go ahead. Yeah, so today is, what is it? It's the 13th of July. These stats are from July 10th, and they're for the full month of July so far, as of July 10th. Awkward. So there's been 148 net unconditional sales so far. Compare that to 510 for July of 2022 for the full month. So 1/3 of the way in, extrapolate that out, you'd have 450 if we were still on target. But I suspect we're going to see slower and slower sales as well as we move towards the end of the month. So probably going to end up with 400, 375.
Why do you think we're going to have slower sales?
Well, it typically happens. Even though I was saying it's been busy and I feel like it's been busy, we typically see it start to slow down here in July and August. So that's why. You know what? Let's circle back and see. I'm gonna predict, well, under 510 for sure. I'm gonna predict, let's say 400.
Okay. I'm surprised at the numbers because last year felt slow compared to the previous months, obviously, right? It felt like the market just ended in May last year and it was slow. I was looking at my numbers. I think June was my last big month last year. But I do find
so what's your number, Jane?
Pardon?
I said, what's your number? Pick a number.
Okay. I'm going to go with 450.
450. Okay. All right. Let's circle back on that.
New listings is low, though, at 283.
New listings, 283 so far, 1/3 of the year, way into the month. 283 new listings. So that makes for 1,100. There was 1,101 for the full month of July. And yeah, again, if there's less new listings, there's going to be less people buying. So I think that helps reinforce my argument.
active listings though at 2344 compared to 2162 last year.
Certainly up for active listings. Yeah.
Okay,
Okay.
go ahead, start us off.
Yeah. So new listings were 276 in the last week. 159 properties went pending. So that's just about, I don't know, 60%. I'm not doing math. I'm just looking at the percentage on those bars. Price decreases 109 still. Like we're seeing, as we've been seeing for months now, these large numbers of price decreases with every one of these stats. So definitely people making a lot of corrections. No price increases. That's good to see. 4 properties back on market. 163 properties transacted at the law offices and land title. 34 properties expired unsold, and 4 properties were withdrawn.
So we just expired 2 properties and we're relisting them at new prices.
Yeah.
And often agents they're like that. We don't think that's fair, or buyers say we don't think that's fair. But if you're working with a realtor, you're going to see days on market total. The strategy behind that is just for people who delete a property based on price, which I always tell my clients don't do off your portal, is to keep that property on so you can see the price reduction. This will show up on more people's searches. And the only reason why I do it is because it works.
Well, yeah, I mean, fair is all's fair in love and real estate. And fair is, we're trying to help people expose and promote their properties. And if they're making a dramatic price reduction, I don't usually do a take it off market and relist for a price reduction that's kind of more standard. But if you're doing a dramatic course correction, I think it's really important that that property be relaunched because it probably maybe was mislaunched at the beginning. We sometimes make a misjudgment around who we're marketing to, how the write-up is, what the primary photo is. All these things go towards the reaction that people have right off the bat on the property they see. People are very visually oriented these days. So let's switch it up. So anyway, it's just a good strategy and it's something that it does work. So I think we should do that.
Why don't we just call it like it is, that they have short attention spans?
Yeah, everyone these days. Yeah.
Okay, so let's get to the meat of today's presentation.
Mhm.
So please welcome Nicholas McKnight. He is with the we call it McBOP. Did I do that?
I did that. Oh, I was looking for his thing. There it is. Sorry.
McCon and Beyond O'Connor and Peterson Law Group. He's a specialist in wills and estates. Welcome, Nick.
Thanks for having me.
How are you doing?
Excellent today so far. How about you guys?
Good. Okay, Andrew, pick either you or I are going to play with the screen, but it's not going to be both of us.
Fair enough.
Okay, so one of the things that happens, so ironically, I was at a celebration of life today for a friend of mine in Kitchener-Waterloo, Ontario, same as Andy McKinnon. I'm still talking about him in present tense. He was only 46 years old, had 2 teenagers. His wife worked with him, and he passed away last year. And of course, I don't think he was prepared to go. He was scuba diving with his son, and he had a heart attack on the water. So, but this is fairly normal that people just pass away. And I'm wondering, so in his case, I don't know if he did or not, but what happens if you don't have your will set up and you're married, for instance, or if you don't have your will set up and you have no family? What's the difference between the two? How are they handled?
Yeah, well, so that's a loaded question, Jane, but it's a good question. There's a number of consequences of not having a will, and when you have children or when you have a spouse or even significant assets, that's particularly the case that you should have estate planning done. So to outline some of the issues that can arise when you don't have a will. First and foremost, and this goes to your question, your estate will be distributed under the rules of intestacy. So intestacy is the term used for when someone dies without a will. and is left no instructions as to how they wish for their assets to be divided and distributed. So when that happens, provincial legislation governs how the property will be distributed among the surviving relatives. So if you have a spouse, they'll typically receive an initial lump sum plus a portion of the residue of the estate, as well as children if you have them. So when there are no children or spouse, the estate generally goes to the next of kin down the line, all the way to first cousins. So, to answer that question, if you don't have a will, your estate will be distributed according to statute. Your will outlines how you want your estate to be distributed. If you want it going to your spouse and your children in shares of the estate, then it's probably not a big deal. But oftentimes people want to provide gifts to certain people, outline what certain amounts people may receive. So to answer your question, it depends on your family, but it also depends on what you're looking to accomplish with your estate planning. And oftentimes people want to be in the driver's seat when it comes to their estate, as opposed to letting the Estate Administration Act outline how that money should get distributed.
Probably creates a lot of additional angst for family members too when there's no will, because there's no clarity. And
absolutely. I mean, it's already a challenging time in the family's life. So you're going to face additional administrative burdens. I do a lot of estate administration work, oftentimes for people who don't have wills. And, I can tell you that even when you have a will, the court system can be challenging to deal with respect to probate. And that's only amplified in cases where there is no will.
Right.
I think another really important part to it, and maybe this will dovetail with our discussion later, is that, one of the most important things with a will, if you have minor children, is guardianship for those children in the event of an accident. I know, Jane, we just discussed about that, terrible accident that occurred. But, if you have minor children, oftentimes your will explain, who those legal guardians will be. Now, if there's a surviving spouse, that's not an issue. But,
right.
For example, if there's a car accident, you may wish your will to explain who's going to have legal guardianship of your children. Otherwise, a court order is likely going to be required to select a guardian for your child. And obviously, you're not going to be involved with that decision.
I have a question.
Yeah.
So what happens when there is a discussion amongst the family, they don't agree with the will, and who should be the guardian?
Well, my advice is that you should always discuss in advance before putting anybody in your will, whether that's as a guardian or an executor, because it's a big role to play. Obviously, you're going to be taking on a lot of responsibility. So, I never draft a will without advising the client that they need to have that discussion prior, because if it comes to it where both parents die, for example, and there's a legal guardian appointed, and that guardian's not willing to step into the role, again, a court order may be required. So, when I do estate planning for people, it's not as simple as here's your will, sign it, you're good to go. It's what I like to refer to as a more of a collaborative approach with the client to try and really understand what their assets are and how they want their estate dealt with, and whether that's dealing with minor children. We also see a lot of cases where people may have a child who has special needs, and they want to include some sort of trust provision which outlines that perhaps the executor will provide them with certain funds periodically, as opposed to here's a big lump sum, go buy a Ferrari. That's a consideration as well.
Go ahead, Andrew.
Yeah, so I was curious. You were saying earlier that if this intestate, how do you pronounce that?
Intestate.
If it's intestate, and you said it usually goes to the spouse first, would that include common law, or is it what is defined as spouse in that sense?
Yeah, so your spouse. Well, that's a good question. Now, A spouse is under common law, is, that definition has evolved over the last few years, as you know, that, there's not, arguably not as much importance placed on, whether people are married these days. Oftentimes people don't marry. The common law states that you are a spouse after 2 years of living together in a common law relationship. However, there is case law that's starting to come out, which recognizes that there may be situations in which there wasn't 2 years of continued cohabitation in that sort of marriage-like relationship. But typically the court just looks at the totality of the relationship. If you had, presented yourself as being in a couple, if you owned assets together. So it is a bit of a factual determination.
Interesting. Okay, thank you.
Yeah.
So in terms of real estate, we have people who have all their ducks in a row and they don't have any claims and they file for probate. So first of all, discuss what probate is. And second of all, tell us what is the good outcome of having all your ducks in a row. And then what is the worst case scenario that happens when people file for probate? Because I've had clients who they've had 3 daughters. They weren't my clients. We were purchasing, but the other side had 3 daughters and it took 6 or 7 months. So when should an agent who is going to be advising these clients tell the client they should be applying for probate?
Yeah, well, so firstly, probate refers to, it's a general term referring to the entire process of administration of the estate of a deceased person, including those without wills, but with court supervision. So we often act as executors of estates or as the lawyer for the executors to, assist with facilitating that process. The amount of time it takes for a grant of probate, greatly depends on a number of factors, and those include the complexity of the estate, the number and location of the beneficiaries, which is a big one. Location and form of the assets, so whether those are bank accounts, investments, whether they have property in other jurisdictions is a big one as well. And whether there's any legal challenges to the will. So, my view of it is always to try and start the probate process as quickly as possible, because, like you said, it can take a lot of time. I think the quickest I've ever seen is probably 5 weeks, but I've also seen it drag out for months and months. And of course, that's assuming there's no defects with the application materials as well, which is often the case. You have to get past the court registry, which is the gatekeeper. So that's a consideration as well. I noted the issue with beneficiaries. The first thing I always suggest is to complete the notices to the beneficiaries. So before you can even apply for probate, you need to send notice to all beneficiaries named, or even beneficiaries that aren't named but may have a claim against the estate. And so I've dealt with estates before where, people are scattered across the globe. And so you have to get those notices out. It's always smart to try and start that process as quickly as possible, because you need to wait 21 days after giving notice before you can even submit your application for probate.
Is that considered proof of service?
Yeah, basically. There's a number of forms, I don't know if we can get into all of it today, but there's a number of forms that you'll need to provide to them. They're going to need to sign and typically need to approve of proceeding in the way suggested.
Okay.
Once those documents, or once you have provided that notice, you'll draft the probate documents, or a lawyer will for you. And then, we need to file them, and that process then can take 4 to 8 weeks to complete, or even longer, like you just said. it's one of the big challenges that we have as well is trying to actually identify, especially with intestate people, is trying to identify the assets, in safety deposit boxes
Right.
or, whatever the case may be. You've probably dealt with some estate sales before with a house full of clutter.
Oh my gosh.
Yeah.
Yes.
And trying to deal with that. I mean, it's quite a big job, isn't it?
Well, what the other thing is, actually, I met with somebody yesterday and they knew she was going to pass, and I think all of her paperwork and everything is in order. And but the house is just a mess.
Yeah.
And just getting it all together. Plus there's no money from the estate until
Right, which makes it hard for anyone to do, the person who's executor, to do any work to clear the place out or what have you, call the junk haulers or whatever. I find I've found in the past when I've been working with buyers looking at properties or sellers selling a property that is an estate, that sometimes the executor is actually quite relieved to have a buyer say, I'll just take everything in the house as it is, because generally it's a lot of junk. There might be some treasure in there, but mostly it's a lot of stuff that they just don't want to deal with. And it's been interesting to me how, even in a multiple offer situation, the buyer who says, you know what, you take what you want, leave what you want, and I'll just accept it the way it is. Just put so much relief on the executor that they're like, yes, I'll take that one.
Yeah. Well, and like I said earlier, Andrew, you should always discuss with your named executor before putting them in a will, because as you just said, I mean, it's a huge amount of work, or it can be a huge amount of work. It's very stressful as well. It's not intuitive. So you're trying to figure out what to do with all this stuff, whether it has value, whether you even need to worry about that. That's often where we come in, is that an executor will come to us and say, look, I'd like some help with trying to determine, how to fill out the necessary documents, how to deal with the assets. We also act as executor, as usually with clients that we've known for a long time who have comfort with us. So it is a big job, and it's not to be taken lightly.
What's the compensation for somebody who is acting as an executor? Is a percentage, right?
Yeah, it is. Typically it goes between about 2.5% to 3.5%. Now, if an executor, though, is a beneficiary of the estate, it's going to behoove them to not probably take a huge amount, because oftentimes you're taking out of your inheritance in any event. So in those cases, you may see people not take any sort of executor compensation other than for out-of-pocket costs.
Right.
When lawyers act, typically we see 2 to 3%, maybe 3.5%. I think, technically you can go up to 5%, but it always feels like that's just too much, unless it's a really complex estate. Most of the time that's not a reasonable amount to charge someone.
Right.
So,
Right. We get approached by people, when there is an estate to sell, and we see, oftentimes there are properties listed that are estate sales, and they're often subject to probate. In other words, they're being sold, but they can't be, offers can't be accepted other than subject to probate being granted. And the challenge being, when you're talking about a time span that could run between, let's say, 5 weeks and months and months and months, buyers are often not looking for a home 7 months down the road. They're looking for a home within the next 1 to 3 months. And so that becomes a bit of a challenge. So understanding and being able to navigate that, because you want to have the property on market as soon as you possibly can. And best, it's easiest to sell after probate's been granted, but many people don't want to wait that long.
Also, on the marketing side, we're advertising it as current, even though it's got an accepted offer, but it's pending the last condition, which is the seller subject to probate.
Yeah, that's a semantic, and that's really a problem within our own systems, in terms of, we just can't mark a property sold until probate's been granted, but it still shows as available. But that's sort of, I guess that's within our own industry. But often we'll find in the background notes, I have clients calling all the time, buyer clients, saying, hey, what's this property? It's been around a long time. It looks like a good deal. Why has it been on market for 100 days?
Yeah. Well, as you noted, you can't transfer title to a new owner until probate's been granted.
Mhm.
So, with it taking months to complete, and it can be completely out of the hands of the lawyer and the clients, it's a challenge for sure. There are sometimes, situations in which an estate may receive an excellent offer and, accept it, but the buyer wants to take possession of the home prior to the granting of probate. But there's a lot of legal issues that can arise in those situations. So, it's very much you have to be very careful, with treading that line. As you noted, there needs to be contractual clauses that say subject to probate. One of the advantages can be that, if the buyer does take possession, they may be on the hook for, fees associated with it, insurance, for example, utilities. But the risks, can, in my view, outweigh the benefits. There may be a new will that comes to light with different beneficiaries, for example. One of the most important ones is, and I do a little bit of litigation still, is a will's variation action. Once probate's granted, the someone who wishes to challenge the will has 6 months to do so, 180 days. So it's a short limitation period to bring an action, but there is a risk there that even after probate's granted, the child who gets left out of the will, for example, could bring an action, and that could then bring into all sorts of issues relating to the house sale.
I found that usually a home sale isn't held up, but the assets get put into trust. It's generally how it's dealt with, but obviously it could happen in anything can happen. But
it can be a challenge, right? So that is that. Typically, I suggest that until that grant has been completed, you shouldn't seek to enter into any sort of contract for sale of the property. But I get that there's situations that it may make sense, especially if you get a great offer on a home. And again, Jane, to your point earlier, another reason to try and start the process as quickly as possible, because it can take time, and it can also, be a benefit to get a lawyer involved to try and streamline that process at least as much as we can.
I do find that the seller is trying to, the executor is trying to maximize the opportunity in the market. So if somebody passes away in December and March comes along and we're in a hot market and they can't sell it, we get pressured to put it on the market.
Of course.
Absolutely.
When it's completely out of your hands.
When it's completely out of our hands. Yeah. So it's always a balance. You're always trying to do both. I also find that subject to probate causes a hesitancy on the side of the buyer. I don't think it's to an advantage to the seller for the buyer to be going, when's it going to close? I don't know.
It's really hard to set an exact date for that. And so a lot of times the buyer maybe has their own home sold and they have to be out of their home by a certain date and time. Buying something that's subject to probate or an estate, a foreclosure, or any of those properties that are kind of unknowns are not a good idea. And that's a conversation that you have with your realtor, you have with your lawyer. You want to make sure that you're getting into the right. These might not be the right property for you.
Yeah.
So I have a question. I'm wondering what should we be telling sellers who are executors for estates regarding getting their paperwork and everything in order? When is the best time to actually, like after the probate's being granted, now we can sell it?
Yeah. You know what? I think, my view of it is that it's always better to wait until the grant has been obtained. Now, I know that's not always going to be an easy conversation, but it's a complex issue contractually, with respect to potential claims against the estate. You never know what's going to come to light after someone passes away as well. The courts have started to take a much more, what I would call holistic view of testamentary intentions as well. So, they'll find a piece of paper in a drawer somewhere that will say, these are my testamentary intentions that will,
I'm pretty sure somebody wouldn't say that, but I know what you mean.
Well, you know what, you'd be surprised. I actually gave a presentation recently on some of the changes to the Wills, Estates, and Succession Act, and and with AI coming in now as well, it's kind of Pandora's box a little bit. I don't know exactly how far the courts are going to go there, but you'd be surprised some of the things they've
How do you think AI is going to affect will?
Well, I think people are using AI now to do their own wills, and there's obviously I'm going to say this, but I think there's concerns with that. I mean, we don't know this technology very well.
Right.
It's a very important decision, obviously, especially with someone who has children, assets. I think that we're going to see a lot of challenges to wills that were drafted with the use of AI. It hasn't happened yet, but we're still kind of on the precipice of this.
Wow. I think that's such a big mistake.
Yeah.
So that actually dovetails into our last question. What is the future of estate planning, I guess? And also I have one more question. So I was told, don't give percentages, give amounts. Because if you give percentages, you have to wait for everything to then be done before you can start allocating amounts.
Yeah.
What is this in regards to, Jane? What do you mean by that?
If you're giving, so for instance, in our own will, we were giving 5% to a charitable organization, whereas now I'm thinking we give an amount.
Yeah. Well, I think it depends as well. If it's your residue of your estate, so after the debts are paid, gifts are paid out. If it's the residue, I think it's easier to do shares, percentages, for example. I have 3. So for example, if you have 3 children, 33% to each of them. With charitable donations, I think it's a better decision to put in a specific amount because you don't know what your assets are going to be at the time of passing. You could come into money, for example, after your will has been drafted, and that 5% to that charity is going to be a whole lot more than it was, when contemplated at the time. Mm-hmm. So with gifts and with charitable donations, I almost always suggest to the client that they provide, like you said, a specific amount as opposed to a percentage. Less worried when you're talking about the residue of the estate to beneficiaries, for example, your children or siblings, whatever the case may be. So that would be my view on that. I did just wanted to just discuss one more issue briefly with you both, okay. And that's another big part to estate planning, which is incapacity planning. Yeah. You've probably dealt with this to some level with power of attorneys before, but one of the big things that I do is draft powers of attorney and representation agreements. A power of attorney helps both of those, deal with while you're still alive, but if you've been deemed incapable of managing your own affairs. And so powers of attorney deal with financial matters. Representation agreements deal with health-related matters. So to give you an example, I had a sale conveyance not very long ago where the gentleman had dementia. And so I had to deal with his attorney, who was his child, in getting the deal across the line. If he didn't have a power of attorney, it would have been very challenging to deal with that sale. Mm-hmm. So, those are 2 other documents which I always suggest people consider because you never know what's going to happen. Anything can happen in your day-to-day life that, all of a sudden everything's changed, right? So, those are very important documents as well, in addition to wills.
Right off the bat, just sort of in front of getting ahead of the wills, before we're talking wills, when people are actually looking with realtors to buy real estate, there's a couple of different ways that people can actually put their property into their name, tenants in common versus joint tenants. This all comes into estate planning as well and is something that should be considered. We talked about, one of the discussions that we have with our clients when couples are buying together or there's someone with some money, the family members giving money to children and so on and so forth, depending on how it's configured can affect how the estate flows. So these are all important factors I think people need to consider as well.
Yeah.
as part of the holistic package. And, you know, like what we do when we're helping people buy a home is we look at it from a holistic standpoint. When you are helping someone in an estate, you mentioned too, it's like, we're not just talking about bricks and mortar or dollars and cents. We're talking here about, you know, what is the background intention? What are you actually trying to accomplish here? And what, how do we make that a reality for you?
Exactly.
How do we translate that into the legal landscape?
Exactly. And to your point there, Andrew, other than the documents I've discussed, there's also consideration of joint tenancy versus tenancy in common. There's also discussion of beneficiary designations because those fall outside of the estate, and that you can avoid probate tax that way. So it's not as simple. Well, I suppose it can be as simple as drafting a will, but my advice to clients, prospective or otherwise, is that, you know, really my goal is to get a firm understanding of what you have, how that's owned, whether, you know, jointly or not, and, you know, what you're seeking from your estate, and that's not, you know, something that should be done, you know, without much consideration, in my view. And you know, especially with people who have, you know, a number of children or, you know, significant assets. You know, it's a very important, you know, strategically, and you know, we need to kind of figure out what you're looking to do.
I have a confession to make. My will is definitely not up to date. And, you know, I had a will done many years ago, and that lawyer retired, and we can't find a copy of that will anymore. And so I'll have to probably get a whole new will done up. And then the old will, you know, would have my ex-spouse as beneficiary and so forth. I mean, it's a mess. I think it's time to do something about this. But my confession is also to say, I think I'm not the only person out there that is probably well behind in their estate planning. And really,
well, it's not something that you really want to think about, right? I mean, that's the reality. It's you're thinking about what's going to happen after your passing. It's not always a you know, enjoyable conversation to have. But, you know, I always suggest to people that when big events happen in your life, so whether that's the you know, a new relationship, a marriage, or a dissolution of a relationship, or purchase of a property, that's always a good time to at least review your estate planning and potentially draft a new will or new, you know, POA or whatever the case may be, you know, based on those changes. Because, like you said, you know, things change in our lives, and, you know, you want to be prepared.
Absolutely. Absolutely. I saw that look of shock on Jane's face, but you just nodded knowingly.
Well, I think you're lucky that perhaps you have an understanding ex-spouse, but there may be people who aren't so understanding. I've seen personally how mental illness can cause issues with the states and all that sort of stuff. People use the system. So get all your affairs in order. Nicholas, thank you so much for joining us today. How do people reach you?
Yeah, so like I said, Nicholas McKnight. I'm at McConnon, BN, O'Connor, and Peterson. We're right downtown on Douglas Street in Victoria here. You can reach me directly at 604-345-8107. Alternatively, you can email me at N for Nicholas, McKnight, MCKNIGHT, at McBOP.com. Or you can call our office number, which is 250-385-1383. And, you know, I'd be more than happy to have a discussion with you, whether that leads to actual estate planning or not. You know, always happy to have a discussion with a prospective client.
Okay,
Excellent.
awesome.
Yeah. And also,
Thank you.
I wanted to say thank you to both of you for having me on today. It's been a pleasure. You didn't make this too challenging for me, but it was a good organic conversation.
We were holding the hard questions for next time.
Okay.
All right, thank you. We'll
Thanks,
continue
guys.
on. We'll send you a copy of the presentation. You want to stick it on your LinkedIn profile.
Thanks so much.
All right,
Thanks,
take
Bob.
care.
Have a great day, guys.
Meet you, Nicholas. I know.
Okay, Andrew.
And there were two.
What?
I said, and then there were two. It's like
And then there were two.
Survivor. we've lost Nicholas, and then which of us goes next?
So let's talk about needs and wants.
Oh man.
What do you have coming up?
Potentially, I've got. She's still getting it ready, but I've got a top floor heritage conversion condo / townhouse, 2 beds, 2 baths, in the Central Park area. That one's probably going to come up late summer. Half duplex on in the Jubilee area is coming up at some point. Been promising that one for a while because my client's been promising that one for a while. I know that's coming soon. I'm going to be meeting some folks about a nice water view property on Friday. Hopefully that will come together, and that's something up near Brentwood Bay. We'll see. And I think I'm missing something. I know I'm missing something, but in terms of stuff coming up that's actually signed and ready to go, nothing yet. A lot of buyers though, ready to pull the trigger, and especially needing a townhouse, rancher style. We're now looking in the West Shore as well, and that's actually probably a preference. But anywhere I would say in the core, not Central Saanich, but in the core out to the West Shore, that would be really a good one. A half duplex or small house under 750, which is possible for a half duplex. Small house in the West Shore, perhaps. A really nice house, like 1.7 to 2.7 million. Water views preferred, but not necessary. Actually, I've got a couple buyers in that kind of price range. How about yourself?
I don't know if you can hear. I have a blower in the background. So upcoming listings, we were just doing a price reduction on Gladstone, 1558 Gladstone. We're going down to 1,149,000. I think that should bring us in the offer category. And we're also just going in, bringing our price down to 1,149,000 as well for 2520 Glendoick Way. That's in Mill Bay. That's a gorgeous house, like really nice. The one on Gladstone is 2-bedroom up, 2-bedroom suite down below. That's located on a large lot. And the one on Glendoick is one single family, 3-bedroom plus office, and gorgeous yard. It's on a corner lot. And I have clients looking for a townhouse in the West Shore. I also have clients looking for a beautiful home in Central or North Saanich up to 2.5 million. So I can't even believe I'm saying that.
Let's have a conversation about that. I'd like to know more about that because I may have a connection.
Okay. Alrighty. And so I think we're done for today. Let's just say to people, if you want to get involved in our show, please send us a little message. We'd love to have you as a guest. Next week, we're going to be talking to a lawyer again. We're going to be talking about divorce. So much fun, as Andrew said. But if you like our show, please like us. Don't forget to subscribe. Give us a comment every once in a while. We want to know that we're not just sending this out into the ether, and share it to your friends and family who we think may be interested. Don't forget, we're on every Thursday morning at 9:30. You can log on here, or if you'd rather listen, you can listen into a podcast at any podcast station you listen to. Alrighty? Okay. Andrew, how do people get in touch with you?
Reach out. I'm at 250-360-6106. Email info@andrewplank.com, or check out the website, andrewplank.com. Instagram is plankandrew, just to be a little different.
And you can reach me. I'm Jane Johnston with Briar Hill Group at Remax Camosun. My number is 250-744-0775. My email is briarhillgroup@gmail.com. Or you can watch this show and other shows at victoriarealestateshow.com. And you can find me on Instagram at realtyteacher_remax_Victoria. Alrighty. Love you, buddy.
Take care of yourself, and we will see you next week.
See you next week, Thursday at 9:30. Bye.
Bye.